Welcome to the latest episode of Employment Talks, a Lydian podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Hello, everyone, and welcome to the 6th episode of Employment Talks, a podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Employment Talks is a Lydian podcast. Lydian is a full-service Belgian business law firm with a practical and personalized approach to practicing law. Through a fine blend of transactional law expertise and litigation skills, we deliver straight to the point solutions that add true value. We think client-focused, we act fast, and we speak frankly in a language that you understand. From our offices in Brussels, Antwerp, and Hasselt, our mission is to find solutions through excellent legal insight and strong business instinct. That is how we exceed expectations, deliver consistent results, and forge long-term relationships with industry leaders. Counting 17 lawyers, Lydian's Employment, Pensions and Benefits team is the largest team you will find in any independent Belgian full-service law firm. We take pride in the size of our team because of the responsiveness it allows us to bring to our clients every day. But even more so, we are proud of the expertise that comes with it. All 17 lawyers, from associate to partner level, advise clients on general employment law topics, from the start until the end of the employment relationship and everything in between, both on an individual and a collective level. Additionally, every lawyer has specific fields of interest, ranging from privacy, health and safety, pensions and benefits, to internal investigations and international employment. My name is Kato Aerts. I'm a partner in the Employment, Pensions and Benefits Department of Lydian, and I'm delighted to be your podcast host. Today, I'm meeting with Sarah Witvrouw, Associate of the Employment, Pensions and Benefits Practice at Lydian and based in our Antwerp office. Sarah has been with Lydian for 2 years and a half. Her expertise spans individual and collective employment law. Recently, she wrote an article on internal investigations together with other lawyers from Lydian. Sarah, welcome. How are you today?
Very good, thank you. This is my second episode for this podcast. I'm happy to be here and talk about a new topic, internal investigations at work.
Internal investigations, that sounds like a serious topic and like a lot of work for companies too. Under which circumstances would an internal investigation be necessary?
In our day-to-day practice, we often receive questions regarding irregularities committed by employees, like fraud committed by a CFO, theft from company stock in the warehouse, accounting staff members changing figures in the annual accounts, aggression between staff on the parking lot of the company's premises, and so on. Of course, companies take these allegations seriously. The first question that pops up for employers is, of course, what to do and how to respond. In order to be able to determine that, however, companies need to know what really happened. Often these facts are reported orally by a colleague or a client or discovered by hazard. In other words, there is no written evidence or clear documentation demonstrating the infractions committed by company staff. It would also be imprudent to act merely on the basis of assumptions or allegations. While being faced with uncertain evidence, the employer, of course, wants to take action if the allegations would appear to be true. In those cases, it is often recommended to investigate the allegations to get a clear view on what happened and take a close look at the uncertainties, if any, in relation to the reported matter. It is necessary to conduct an impartial investigation to obtain a reliable image of what happened, and this, of course, needs to be done thoroughly and swiftly, and also while making sure that there is a fair process behind it. Eventually, the aim for the investigation is to result in factual findings that are a reliable basis to take further action.
Of course, that makes sense. So at the start of such investigations, Sarah, I'm sure employers often ask who needs to conduct the internal investigation and how do they start?
Yes, indeed. And launching the investigation properly is a very important step. Bigger companies sometimes have a separate department that is established specifically for this purpose. These companies conduct investigations on a regular basis as allegations come in more often, given the number of employees employed at the company, and therefore the number of cases that have to be looked into, it's quite big. Smaller companies often do not have such a separate department. When they are faced with allegations which they would like to investigate, they often turn to managers or HR personnel to conduct a small investigation. In both cases, it is recommended to think of a good composition of your team each time a complaint or a report pops up that requires further investigation. Firstly, you should consider which expertise and skills are required to investigate the matter. If the report is related to tax fraud and requires a specific knowledge of accounting, an HR staff member might not be the best fit to conduct an investigation. It might be recommended to appeal to the services of the head of the accounting department, for instance, who can assist the HR staff member in her investigation. Another example is that not everyone feels comfortable with interviewing employees as alleged offenders, victims, or witnesses. The skill to interrogate people with the necessary professionalism, confidence, and decisiveness certainly is a good skill to have among the people in your investigation team. So, when assembling a team, be aware of this and try to use the expertise and value of every member of the investigation team to the fullest. But bear in mind that from a confidentiality perspective, it is best to keep this team as small as possible. You wouldn't want the whole company to become aware of the ongoing investigation and jeopardize the individual's privacy.
Of course, that seems very important. So, Sarah, that's all clear, and it certainly is wise to think about composing a good team to conduct the internal investigation. But what do companies do when the person they would normally turn to conduct such internal investigation, for instance, someone from HR or legal, is involved themselves in the reported matter? For instance, if they themselves have been the victim of an act of aggression or if they are the alleged perpetrator.
Yes, that is why it is also important to check whether anyone within the investigation team has a conflict of interest. If someone has a conflict of interest, for instance, because they have always been close to the alleged victim, or even if this only appears to be the case, they should not be part of the investigation team. Perhaps one final comment on that composition of the investigation team. It is also important not to involve a person who is competent to terminate the employment relationship or to impose a disciplinary sanction. To verify this, a company should check its articles of association or power of attorneys that have been given to the HR colleagues, for instance. The purpose of the investigation is to first get all the facts straight and to finalize the investigation before informing the person who can decide on the next steps on behalf of the company. Indeed, if they would already be involved during and in the investigation, this could trigger the start of some strict deadlines to take action under Belgian law.
Sarah, could you perhaps explain what you mean with the latter? What does that mean? Are there any deadlines that companies should take into account when conducting an investigation?
Yes, there are in fact some deadlines, not necessarily in relation to the investigation itself, but depending on the action a company is considering to take after finalizing the internal investigation. If the internal investigation is related to employees and the investigated infraction qualifies as a serious fault that could justify dismissal for cause, in which case the employer does not have to respect a statutory notice period or pay a statutory severance payment, an employer only has 3 working days to proceed with such a dismissal. This term starts as soon as a person who's competent to dismiss has obtained a sufficient level of knowledge of the committed infraction. So, if you would immediately involve, let's say, the director of the company who usually dismisses personnel in the investigation, if he would himself take interviews with everyone, confront the employee with the investigated facts, and so on, this deadline of 3 working days might start running during the investigation itself, as he might already obtain sufficient knowledge of what happened early on in the investigation. And that is something that you want to avoid because you want to conduct a proper investigation. And to the extent possible, you also want to avoid a discussion before a court whether or not you have respected this 3 working day deadline. So it is very much recommended to leave the individuals who are competent to dismiss individuals out of the investigation altogether. While case law confirms it is prudent to conduct an internal investigation to understand what actually happened, the company should also be aware that this does not allow them to conduct an endless investigation. In other words, it is important to conduct the investigation swiftly. What might help to establish this, as the allegation that the internal investigation has taken too long is something employees usually argue in court proceedings, is to include a detailed chronological timeline of the measures taken during the investigation in a written investigation report, indicating, for instance, the reasons for delay. For example, if you want to take an interview from a key witness who is on holiday, it is recommended to include this in the report itself. Or if you are waiting for a reaction from public authorities, it is also good to indicate the date on which a request was submitted and to send regular reminders. A dismissal for cause and a 3 working day period is not the only deadline to keep in mind if you are investigating employees and you want to take measures after termination of an investigation. If a company decides not to terminate an employment agreement, as they still see a future with the employee, but they do want to impose a sanction like a formal warning or a fine, they should give a clear signal, and the employer should therefore first verify whether this sanction is provided in the work rules. And secondly, they should impose the sanction at the latest on the first workday after establishing the infraction. This sanction should also be noted down in a register. So here again, we generally recommend to keep the competent persons who can impose sanctions on behalf of the employer as far away from the investigation as possible. Only after the investigation is final, this person can be informed and the right action can be taken. Not only for employees, but also for self-employed persons, it is recommended to take action in due time following an internal investigation. It is best to also check the contract for any deadlines with respect to termination of the agreement or to take disciplinary action. To check what is contractually defined as misconduct or a serious shortcoming, and to check whether it is required to send a notice of default first, for example. Specifically for sales agents, the agreement can be terminated without notice in exceptional circumstances with respect of a 7 workday deadline, and by sending a written notification containing these exceptional circumstances or infractions per registered mail.
Okay, thank you, Sarah. So timing certainly is of the essence here. Now, when it comes to the investigation itself, could you give us more insight in how such an internal investigation should be conducted and what it would look like? Depending on the allegations, what kind of investigation measures could be taken? Could you share some ideas or examples?
Well, as I said earlier, an internal investigation often starts with a report of a suspected irregularity. This can, for instance, be communicated to the HR department, prevention services, or nowadays the whistleblowing channel, depending on the procedures that are put in place for this in the company. For the whistleblowing channel specifically, there are separate rules and requirements. And for those who are interested in this topic, I recommend to listen to our first podcast episode. So naturally, as soon as a report comes in, the recipient of the report will first have to confirm receipt and study the complaint or allegations and determine a course of action. Once the investigation team is put together, the quest for evidence and the fact-finding exercise can start. There's a lot to say on this topic, and several actions can be appropriate. One can, for instance, obtain evidence by interviewing several people, installing a system of geolocalization in a car, using observation techniques, call upon a private investigator, and so on. So I will limit my answer to some key elements that apply to all investigation measures. Firstly, when investigating certain elements like checking camera footage, emails, and so on, the privacy of the investigated individual should be kept in mind. Every investigation measure should therefore respect the legality, the finality, and the proportionality principle. Legality principle, I mean that there is a need for a legal base which justifies the investigation. A lot of collective bargaining agreements, for instance, they provide for the possibility to place and check camera footage, monitor email correspondence, and other kinds of measures, but only if very stringent conditions are met. Another legal source could be the work rules or a policy, although the latter is often drafted unilaterally by the company without consultation of the employee representatives and is not a very strong ground to breach someone's privacy. What is often subject to debate is whether the individual's consent could offer a sufficient ground for certain investigating techniques. However, this is generally not accepted as a ground for intrusive investigation techniques, as an employee who is working under the employer's authority is never considered entirely free to consent with or disapprove any action taken by the employer. This is different for consultants or managers working on a self-employed basis. They can give their consent to conduct certain investigation measures, either at the time of the investigation or prior to that by signing a policy or agreeing to it in the consultancy or management contract. In all cases, It is best to be transparent and inform the staff about the right of the company to conduct an investigation and therefore to take certain investigation measures and, for instance, check emails or cameras. This should be done by clearly indicating the intended purpose of the investigation as well as the potential consequences. Although the letter should not pose any problems as the sanctions have to be included in the work rules anyway.
Okay. And what about the finality and proportionality principle you just mentioned? What does that mean?
The finality principle requires a justified cause for the measures taken. Protection of company property, safety of the employees can certainly qualify as such, but should always be balanced against the reasonable privacy expectations of the investigated individual. And what concerns the proportionality principle, your investigation should always be proportionate to the severity of the allegation. So before choosing an investigating technique, consider whether there is an alternative, less intrusive technique that would safeguard the privacy of an individual to a greater extent.
That's very interesting and a very clear guideline for employers. Now, moving towards the end of the investigation, what should the company do with the findings resulting from the internal investigation? Would you, for instance, Sarah, recommend to confront the individual concerned?
Although it is not a legal requirement nowadays, it is good practice to confront the alleged perpetrator or offender with the results of the fact-finding investigation. And as you said, we would recommend to do this at the end of the investigation to allow the individual to give their version of the facts. Only if you have sufficient evidence and there are other reasons for not interviewing the individual concerned, for instance, if you fear more damage would be caused to the company, there is no need for an interview. In this regard, it is interesting also that there is a new draft law for private investigation pending, which might still get approved before the upcoming elections. This draft act contains general guidelines for taking interviews, including the draft of a conversation report, and might thus be relevant in the future.
And would this draft act also be relevant for other aspects of an internal investigation within a company?
Yes, there might be some impacts. While it is only a draft and we still have to wait and see whether or not the act will be adopted before the elections, it seems that certainly for certain companies that have a separate investigation department, there might be some additional obligations, such as the obligation to retain a register of assignments, the requirement to draft an investigating report, the requirement to provide training for private investigators, and so on. And also, last but not least, to have some kind of internal document policy communicating the type of internal investigation measures that can be taken. I have actually some news at this moment that we record this podcast. It has been voted in the commission, this draft. So let's wait and see whether this will still be adopted in time for the elections.
Okay, very exciting. Let's see what the future will bring in this regard. Thank you so much, Sarah. It sounds like there still is a lot to talk about when it comes to internal investigations. Unfortunately, that's all the time we have today, but many thanks for taking the time to record this episode of Employment Talks with me. I enjoyed it a lot, and I hope you did too.
It was again very lovely to be a guest on the podcast.
The last words go out to everyone who tuned in for this episode of Employment Talks. I hope the content of this episode was as entertaining and interesting for you as it was for me. If you have any questions in relation to the topic we brought to you today, of course, feel free to reach out to Sarah or to myself. If you do not have our contact details yet, make sure to visit us at our website, www.lydian.be, or simply reach out through LinkedIn. This was Employment Talks, a Lydian podcast. If you like this episode, please make sure to subscribe to this podcast wherever you listen to your podcasts, and feel free to leave a comment or share it with people you think might be interested too. We look forward to hearing from you, and we would love to welcome you again in 2 weeks for our next episode. This was Employment Talks, a Lydian podcast. If you liked this episode, please make sure to subscribe to this podcast wherever you listen to your podcasts, and feel free to leave a comment or share it with people you think may be interested too. We look forward to hearing from you, and we would love to welcome you again in 2 weeks for our next episode.